a US government picture, and they're all public domain, at least in the US, and we kind of just fudge it here a bit. All of the slides are openly licensed, and except for the couple that I'll mention as we go through. So if you do want to suddenly take a screenshot of any of them for any unknown reason, feel free, but they'll all be available afterwards, obviously. So we have copyright. The setting of copyright is that it looks like a stop sign, or it feels like a stop sign. It's meant to look like a pile of money, and it actually looks like a tug of war. So there's your sort of general playground. To take about 3 steps back, though, to make sure we're all on the same field, what exactly is copyright? So copyright is basically a property right that protects the expression of ideas. Now, importantly, it protects expression of ideas in material form. It doesn't protect the ideas itself. So anybody is free to hold the idea or the knowledge that Beethoven composited music. However, if you write that down in a poem or you express it in an essay, the exact words you use are protected by copyright. The idea is not, but the expression of the idea is protected by copyright. It also has to be an original expression of an idea. So I can very cheerfully sit down and write out every single word of all of Shakespeare's comedies and tragedies, but I wouldn't own copyright over it because it's not original. If I just reproduce Shakespeare's words, I can't claim copyright over that expression because it's not an original expression. And it has to be created by a person. So if you are a very handsome macaque monkey and you are larking around in a forest and a nice person called David Slater leaves a camera out there and you happen to take this rather handsome shot of yourself, you don't get to own copyright because you are not a person, you are a macaque, and macaques cannot have copyright. Interestingly, in the US at the moment, PETA, what do they call it? The promotion of ethical treatment for animals have actually launched a case on behalf of the macaque, who they have given some stupid name to, claiming that the macaque should be able to own copyright. It's an interesting gambit. I can't see it succeeding, but even if it did for some unknown reason succeed in the US, the Australian Copyright Act is incredibly clear that only qualified persons can own copyright, and qualified persons are not going to stretch to Indonesian macaques. So copyright basically covers every original expression of an idea reduced to material form that's created by a human. So in other words, it basically covers almost anything that you have in your library. So if you have DVDs or you have videos on VHS or you have books and you have comics, you have old business reports, you have local history records, you have the records from a local business that includes charts and tables, all of those sort of things, all of that is covered by copyright. And the important thing about copyright is that it gives the owner of the copyright the only permission, basically, to do things with that work. So only the owner of the copyright has the ability to reproduce that work, to adapt that work, or to communicate that work or publicly perform that work. And anybody else who does that without getting permission or a license or working under some form of an exception infringes copyright. Infringement of copyright is a civil action. So because copyright is a property right, if somebody else does one of these things, it's seen as infringement. And what it means is I can take you to court and I can sue you, and I can sue you for either the damage that is being caused to me by your infringement. So for example, if you decided to steal one of my videos and publicly broadcast it across the country, the damage might be all the people who then didn't bother to buy my video and the broadcast rights that I could have sold to a different broadcaster. They can sue you from, they can ask for an account of profits. So that's if I have stolen this beautiful picture of a kangaroo and used it to put on tea towels and sold them for $1 million each and made $3 million, then somebody can ask for that $3 million of profits. And there's another one called additional damages, which is basically where the court can just make you pay extra money if you've been a particularly nasty person. It's very rare for copyright cases to actually hit court. Most of the time, the money is not entirely very huge, and court cases are quite expensive. So we generally only see maybe half a dozen copyright cases through Australian courts in a year. There'll be an awful lot more that are launched or start and are settled before they ever hit anywhere near a courtroom. The last time a library was sued in Australia was 1977, and that was the Morehouse case, where a university was sued for the absolutely criminal offence of putting photocopiers next to books, which, as I assure you all know, is a horrific idea. How long does copyright last? Well, copyright lasts for different amounts of times depending on what sort of thing it is. As a general rule of thumb, copyright lasts for 70 years after the death of the author. Now, importantly for anybody out there who has historical collections, the 70 years is an extension to what we used to have, and we picked it up under the Australian-US Free Trade Agreement. When we extended it, we very carefully made sure that anything that was out of copyright at the beginning, when the Act went through, stayed out of copyright. So anything that was out of copyright at the end of 2005 stayed out of copyright. Importantly, that means any author that died before 1955, their works are out of copyright, and so we use a term called public domain for that. So authors who died before 1955, out of copyright, and photos that were taken before 1955, because the term on photos used to be 50 years from the date that the photo was taken. If the photo was taken from the 1st of January 1955 onwards, or the author died from the 1st of January 1955 onwards, then the work is still in copyright. For broadcasts and sound recordings, it's slightly different. You're looking at 70 years from the date of the broadcast, or 70 years from the publication of a sound recording. And as some of you may be aware from recent campaigns from ALIA, if something was not published, so if you have an unpublished manuscript, for example, business records are ones that often crop up, or union records, grey literature that was never published, letters, diaries, all of those sort of things, then they're perpetually in copyright. So unpublished works are in copyright up until the point that they are published. If they are published during the life of an author, then the term is life of the author plus 70. But if they're not published after the death of the author, the term dates from 70 years from publication. So up until the point they are published, they are perpetually in copyright, which is a bit of a bugger. And then, of course, you've got the terrible problem of orphan works. Orphan works are basically works where we don't know who the copyright holder is. So if you don't know who the copyright holder is, it's impossible to clear copyright. Even more upsetting are orphan works where you don't know who the author is, because if you don't know who the author is, then there's absolutely no way of telling whether the work is still in copyright, because you don't know the death of the author, so you can't calculate copyright. Unless, again, they're unpublished works, in which case you're absolutely guaranteed that they are in copyright and that you can do nothing about them. I've got a question which I will answer that one in a minute, actually. So there's an excellent question already. Please keep the questions coming through. So we've got copyright protects the original expression of an idea reduced to material form created by a human, and it lasts for an incredible amount of time. In fact, people basically die waiting for it. Because it's a property right, if you're the copyright holder, you can do whatever you want with it, and you can split up your copyright in any way that you wish. So you can, for example, if you wrote a manuscript, a story of some form, you could cheerfully sell the translation rights in Kenya for the period of 10 years to somebody, and sell the film adaptation rights to somebody else in the UK for in perpetuity and give somebody else a non-exclusive license to publish in Asia. So you can split up all of the various different sort of rights within that copyright. So you can split them up by geographical, you can split them up by time, you can split them up by the sort of exclusive uses that you can do, and you can send them all over the place, which is another issue when it comes to trying to clear copyright, because you're never entirely sure, unless you start doing investigation, who holds the copyrights and who you need to talk to get permission or to get a license to do things. Now, some things are obviously better than others. If you're working with a commercially produced film or you're working with a commercially produced book, as a general rule of thumb, approaching the film production group or the distributor or going to the publishing house will probably get you most of the way there. But you can never be 100% sure. If you've got this entire bundle of rights and you're trying to work out who owns copyright, another issue is trying to work out who owned copyright in the first place. So as a default, copyright goes obviously to the person who created it. If I write a book, I own copyright. If I draw a picture, then I own copyright. If I, however, produced, say, a slide presentation in the course of my employment, the default is that my employer owns the copyright. If you ever get contractors to do anything for you, I would strongly advise writing in who owns the intellectual property into that contract, because otherwise you're going to have to go on implied permissions. As a general rule of thumb, as I said, authors own it, the creators own it, but employers own it if it's done in the course of employment. Make sure you do a contract for anything else that's commissioned or consulting or anything else like that. And after you die, as a general rule of thumb, it devolves to your estate. Businesses obviously can own copyright, and if they die, and businesses do basically have legal deaths, then it generally gets split up with the assets of the company. But once again, if you are looking at archival material, if you think that the actual records to show where those went to, sort of where all the various rights ended up exist, then you're doing better than most of us. Okay, a couple of very quick questions here. So we've got a question that says, so a collection of photographs is taken in 1888. It's out of copyright? Yes. And it says it's out of copyright because the photographer died in 1901. It's out of copyright, and it doesn't matter when the photographer died. Before 1955, photos date in copyright 50 years after the photo was taken. So all photos taken before 1955 are out of copyright, regardless of when the author died. If the photo was taken after the 1st of January 1955, then you have to worry about when the photographer died, and then it's 70 years after the death of the photographer. Anyway, that was an aside. The question is, if I own the photographs, can I claim copyright on the images? No, you cannot. They're out of copyright. Pre-55, they are public domain. You cannot claim copyright at all. You can obviously restrict access in a number of ways. You can make people sign a contract that if they view the photos, they won't reproduce them. You can make people sign a contract that if you let them take a copy, they'll only do X and X. But so you can do contractual things around them, but the works themselves are out of copyright. There's a question that says, out of print text, can we legally photocopy an entire text and include it in our library collection if we include a notice stating the official copying notice due to item being out of print and unavailable? If we checked with our normal suppliers and they say it is out of print, is this good enough, or do we have to search worldwide up and down everywhere to ensure it is out of print, even if there might conceivably be one copy remaining for sale at, for example, Amazon, but we didn't check as our regular supplier said it was out of print? So with out of print works, what you can generally do is ask for an interlibrary loan. So there is a section in the Copyright Act called Section 50. It covers interlibrary loans. You can get an interlibrary loan for 3 different reasons. One is to assist a member of parliament in doing their duties. One is to supply a customer who has asked for something under Section 49 document delivery. And the other one is to add into your collection. Now, if it's that last one to put into your collection, you can get, without even questioning it, 10% or one chapter or one article, unless it relates to the same course of research and study, in which case more than one article out of a published work, and that can go into your, and you can ask a library to send you a copy to put into your collection. And that's how much you can do, unless the work is not available at a reasonable time and an ordinary commercial price. If you cannot get the work in a reasonable time, ordinary commercial price, and that's an out-of-print work, then you can request up to the entire item, and then you can put that entire item into your collection. When you're looking at what's a reasonable time and ordinary price, you are looking at just, can you basically buy this commercially? You do not have to search second-hand sites. You do not have to scour through antiquarian bookshops or anything like that. If you can't get it from a general retailer because the thing is out of print, then you can ask for an interlibrary loan of the entire thing. One more question. And there's a couple more, but we'll get to them in a minute. If a work, e.g. a letter, is created by someone at work, can you assume that the copyright is owned by the company if it doesn't say anything on the document? Or do you have to allow for the possibility there was an agreement in place whereby the actual person owns copyright? So there's a couple of things. One, the employer will by default own stuff that you do in the course of your employment. So if it's a personal letter that somebody has written while they were at work, but it's not actually pertaining to their employment, the default would be that they own copyright, not their employer. Apart from that, yes, your default is that it goes through your employer, but a lot of people in their employment contracts may choose to say anything that they create, they do own copyright, or they may own copyright in certain things. Because copyright is a contractual right, then they have the perfect ability to do that. So you can never be sure, but the assumption is that it would belong to the employer, and it would be up to you to make a risk management decision about how sure you are to go ahead with that assumption, or whether it's worthwhile checking out. So to summarize, basically everything in your library collections is covered by copyright. It covers almost everything that you want to do with your collection, and if you get it wrong, somebody can sue you. So what do we actually want to do with our materials, and what can we do with our materials? Oh, sorry. One more slide. The other thing to remember is there's another right called moral rights. Moral rights pertain directly to the author. It means that they are not like other copyrights. You can't sell them, you can't contract them, you cannot give them away. What happens is that they stay always with the author. There are three moral rights: the right to be attributed as the author, the right against false attribution, which fairly obviously goes very closely with the first one, and the right for integrity of authorship, so you can object to people doing bad stuff with your works. They last for the same amount of time as copyright. So if copyright lasts for 70 years after the author's death, their moral rights in that last for 70 years after the author's death. If they last for 70 years after publication, the moral rights last for 70 years after publication as well. So moral rights are the same in that if you breach them, then somebody can sue you. So what do we want to do as libraries? Well, we want to do all sorts of things. We want to have book parades and encourage people to dress up in fancy costumes. Now, is a costume of a book character a copyright infringement? Well, probably yes, because it's a 3D reproduction of an artistic work, and the artistic work is protected. So unless you actually have unless you're using only Peter Pan or Alice in Wonderland costumes, then they're probably an infringement. Is the library responsible for the fact that all of these children are turning up in infringing costumes? Well, potentially, because as well as the cheerful just direct infringement where somebody can sue you, there is another concept called authorization. An authorization is when somebody is held responsible when other people infringe copyright. And this was the big library case back in 1978, where the University of New South Wales was sued for having photocopiers in the library. And what happened in that case is that Frank Morehouse, bless his heart, actually went into the library and photocopied books just to prove that you could actually infringe copyright by daring to have these evil photocopiers next to something that you could infringe. And when it hit court, the court looked at it and said, well, look, what's happened here is the university has put the means to infringe, the photocopiers, next to things that can be infringed, the books. There's a really close relationship between the parties. The library has a lot of ability to control the actions of the parties, and it hasn't taken reasonable steps not to have this infringement happening. It's liable for those students infringing copyright, which is why every single person listening to this webinar, hopefully, has got a sign above every single photocopier and every single computer that is that standard get out of jail free sign that warns people not to infringe copyright. You put that there because that's what keeps you safe from being liable for authorization. But if I advertise a book week thing and I encourage everybody to turn up in costume, am I guilty of authorizing infringement? Well, potentially, yes. Is anybody ever going to sue you? Well, absolutely not. And we know this because we have book week parades absolutely over the place. We do story times all over the place. So when you're looking at this, despite the fact that on a strict legal sense, potentially we can't, a risk management approach would say probably this is okay. And there's another thing to consider, which is whether we can do this under an exception, and that exception would be Section 208B, which I'll talk about in just a second. What other things do we tend to run foul about? Well, we tend to run foul over making things accessible. So trying to write things in Braille, for example, or making things that are in an audio format, or translating things for remote language groups or small language communities within the library. That right of translation is a key right of copyright because it's making an adaptation. So that's another thing that, strictly speaking, might be out of scope. And then there's all the really fun stuff that we do. So people with the digitization of the newspapers. So we've got fantastic digitized newspapers in Australia, and they go up to 1955 as a general rule of thumb, although the Canberra Times, through agreement with the National Library as a birthday present, let the National Library digitize the Canberra Times right through to 1990. So we've got all of this sort of stuff. A lot of the universities are beginning to look at trying to digitize their old theses. A lot of digitization projects around archival collections of unpublished works, and we know they're all in copyright. And that tends to be another cheerful, big, horrible no. So if you took a really strict approach to copyright, it would rather seem as if you can't do almost anything at all. Which is where two things in particular come in as really, well, three things come in as really important for libraries. So the first one are the number of specific library and archive exceptions. So the libraries and archives have exceptions for document delivery, which is Section 49, for interlibrary loan, which is Section 50. Then they've got a stack of preservation copying exceptions that are all moderately useless, but they exist. Some for unpublished works that are almost completely useless, but they exist. And then the users themselves have a whole lot of exceptions. So the people who come into your library have the ability to make copies for things like study and research and criticism and review, reporting the news, parody and satire. You as a librarian cannot make those copies on their behalf, but your users can make the copies themselves for those sort of reasons. And then we have, so that's one set of things. And then we have the big library exception. And the big library exception is called Section 208B, and it is flexible dealing for libraries and archives. The flexible dealing exception basically says it has three different things that it covers. It covers education within educational institutions. It covers making things accessible for people with a disability, and it covers libraries and archives for the purposes of libraries and archives, and for the purposes of libraries and archives includes doing all the things that libraries and archives generally do. So with that one, you have to check that no other limitation or exception applies, so you can't do it somewhere else in the Copyright Act. you're not allowed to make money out of it or not allowed to make a profit out of it. And if it's for the purposes of libraries and archives, then you go through the Byrne 3-step test, which basically it's a terrible old-fashioned sounding test that looks at whether you basically looks at the impact on the rights holder. Is this going to impact negatively on the rights holder? Is it going to take away from the normal market of the rights holder? And is it a special case? And if you follow those steps, basically looking as if this is a fair thing and if it's going to be commercially harmful to a rights holder versus being very publicly beneficial, then you can use Section 200AB. So you've got library and archive exceptions, you've got Section 200AB, and then the other one is just taking a very sensible risk management approach to things. The ones where you sit there and you go, do the benefits of this outweigh the detriments? Is this of a monetary amount that anybody would ever kind of sue me? And coming to a risk management decision about what you do. Is anybody actually going to sue the local public library for inviting the kids to turn up in costume to celebrate Book Week? No, they're not. So you take a risk management approach to things. And when you're taking a risk management approach too, we look at things like risk mitigation. Now I'm going to answer another couple of quick questions here while we're listening in despair, while we're thinking in despair about all the things that are technically breaches of copyright. So, if a researcher at a university publishes data via a university repository that he or she doesn't have copyright for, just move for a second, who is liable? The researcher, the university, or both? Okay, so there's an interesting question here for a start. Data in and of itself is not protected by copyright. So copyright only protects the expression of ideas. Pure data and pure facts are not covered by copyright. However, the selection and arrangement of data can be protected by copyright. So if you've got a whole lot of data and you've picked it up and selected certain bits of it or arranged it in certain ways and arranged it in a way that is not obvious, then you may have copyright over that data set. But if you don't, and it's just pure data arranged in the most obvious fashion, there will be no copyright over that data set and you won't have a problem. That's in Australia. In the EU, if you're ever playing in the EU, they've got a special, not copyright, but a sort of super right called the Database Directive, and it has a special protection just for databases. But let's pretend that we've got data that is actually protected by copyright. If a researcher publishes via the university repository, who is liable? Most probably the researcher. If the university is liable, they may be liable for direct infringement, but it would be a bit of a stretch. They're unlikely to necessarily have the authorization for that publication, but it will depend a lot on the actual relationship between the university and the researcher, the level of control that the university has over the researcher and the researcher actions, and whether the university has taken any reasonable steps to ensure that the information is correct and copyright has been cleared. What most repositories or most universities would do to try and protect themselves is to, one, get all researchers to warrant that they have the right to use all of this, either warrant that they own the copyright or they have the appropriate licenses to put this into the repository. And second, you can ask the researcher to indemnify you if they don't actually have the rights. So they indemnify you. So if somebody sues and they join the university in a suit, then the researcher has indemnified the university against any legal outcomes. Quick question, can the 100% copy, if not commercially available, be put online or only added to the collection in print? At the moment, all of that is governed by Section 49. You would only be able to put it in the collection. You could probably make it available on a dumb terminal within your building. I realise that's not very useful, but that's how it is at the moment, unless you can swing it into a Section 200AB kind of analysis, and that's a really interesting edge of 200AB that nobody's really tackled yet. If we take photos of book characters in costume parades and share those photos on social media, is this a breach of copyright? Yep, pretty much yes. Yes, it is. Is anybody ever going to sue you? I would doubt it very much. What would they sue you for as a reasonable guess? What possible harm can somebody have suffered if you have put a picture up of somebody in an infringing costume? And a really strange case, maybe they've given people a really excellent idea to make a cheap costume instead of buying the expensive licensed costume. I doubt very much that would ever happen. And look, almost all copyright sort of things in Australia anyway start with a bit of a random takedown procedure. So somebody will send you a letter first and say, please don't show that video anymore. The other big thing to say is, well, is this a section 200AB thing? Is promoting reading and literature a key purpose of libraries and archives? Yes, it's a key purpose of libraries and archives. Is this a special case? Yes, it's a small community group and we're looking at promoting Book Week. Book Week is a set space and time. Is this undermining the rights of the rights holder in any way, shape or form? No, it's not. It's probably, you would argue, not actually a breach of copyright because it falls within section 200AB, flexible dealing for libraries and archives. Okay, we'll pause on the rest of the questions and steam through for a second. How do we do risk management? We do lots of risk management. So one of the things is to promote a lot of information to users. So a lot of the admin time that comes to libraries about copyright is not even so much what the library can do, it's users asking what they can do with copyright. So this is an example from the State Library of South Australia, who produces quite a lot of information to their users about what they can and can't do. When you put up stuff that you're not sure about copyright, there are a couple of things you can do. So you can put up a thing that says, look, we don't know that this is out of copyright. We suspect it is, but we're not 100% sure. If you are going to use it, you are making your own risk management decision about this. One of the other things that you can do is try and get people to come forward and talk to you about their ownership. So when you're using things like orphan works, one of the most successful things that the library sector and the cultural institutions have done in this country is they've put up a lot of orphan works and they've said, hey, look, this is an orphan work. We don't know who owns copyright, but if it's you, could you please come and tell us? We'd love to hear from you. And that does a lot of things. It means that if somebody does come across it, instead of feeling like somebody's ripping off their stuff, they've got an open invitation to go in and actually talk to the people. And we find that it sets up the conversation on a really good footing. Over the years where Australian institutions have got increasingly brave about digitising things, nobody has ended up in court. Nobody has, even as far as I know, come close to ending up in court. There have been a couple of NACI letters, but almost overwhelmingly, the feedback has been incredibly positive. And when people find photos or documents online, instead of saying, oh my goodness, that's my copyright, how dare you put it up without my permission, the general response has actually been, oh my goodness, that's my Uncle Jack and that's my great uncle's shop, and this is some more information, and would you like more things from my family's collection to put along with this? So if you're playing with orphan works or you're playing with no known copyright restrictions, the best thing is to be really open with it. Make sure that people are making their own risk management decisions. You put it up under section 200AB, flexible dealing for libraries and archives. Explain to people it's their own risk management decisions, and invite the general population of Australia to come into a conversation with you around these works. So risk management is all about taking sensible risks and not feeding your babies to crocodiles. When you're looking at risk management, the key things to be looking at are what dangers are you looking at? And we know that what you're looking at in copyright infringement is monetary damages. So if you are doing things that have no monetary damage to anybody, they're very low risk. If you are going to rip off Disney, that would be an incredibly high risk and really not a good idea. But when you're dealing with, say, unpublished theses, that nobody has looked at since 1940 and have no commercial value because nobody even knows they exist, then you're looking at really low risk. Don't remember that while they might be the legal risks, the other risks that you run have more to do with reputation, admin costs and staff, because nobody likes being sued and it's quite a traumatic experience for people. So those go into them. With your reputational risks, it's always important to remember that it's a two-sided coin. So you might have a reputational risk if somebody sues you for copyright infringement. Or if somebody goes to the paper and says, I can't believe that the State Library of Queensland has ripped the copyright off and hasn't sought our permission or anything like that. On the other hand, you will also suffer a huge reputational risk if you sit on these collections and don't do anything with them and nobody knows they exist, at which point the governments think, why do we bother funding you? Because none of this is actually being used. So always in a risk management thing, you've got to weigh up what your actual risks are for copyright infringement versus the risks of not doing things that are actually generally very important projects. So when you're, one big thing is using your exceptions. So you've got your library and exceptions, you've got your flexible dealing exceptions, and you need to use those. Another is to take a sensible risk management approach. And then another thing that we need to talk about very quickly is looking at what you can do to be really positive and proactive in this space. And that includes doing things like embracing open licensing, and making sure that you, for example, know how Creative Commons works. There are lots of open licenses, but to be honest, Creative Commons is the widest known, the easiest to really get engaged with because they've got the best material available, and it's a very good one to seamlessly integrate with everybody else who's doing open access. So knowing about things like open licensing and Creative Commons, knowing about open access. If you are working especially in a research institution or in a university, or you're working in a corporate library that where your people need to use research articles, promote open access. The more open access we get, the more copyright ceases to be such an insane bugbear that ruins everybody's sleep at night, or possibly just my sleep. And get a bit activist. So probably not actually at the stage of burning books, but definitely at the stage of baking cupcakes to try and bring attention to the fact that perpetual copyright in unpublished works is a stupid idea. It is a stupid idea, by the way. The Cooking for Copyright campaign that I hope a number of you saw, where we actually asked libraries to send us unpublished recipes, and we, in flagrant breach of copyright too, I will point out, published them and got people to cook from them, had almost 1 million, basically had 1 million social media hits. So we're talking about one of the biggest library campaigns we've had. People do care about copyright as long as you can add food into it and make it fun. Okay, I'm looking at the time and I have precisely 2 minutes to whiz through what's happening in the next little bit, and then I'll come back and answer all the questions that I know are popped up both in my Q&A and in the chat. So very quickly, that's an obligatory kitten. What's been happening in copyright? Well, we've had 3 really big bits in copyright. We've had website blocking that went through. We have a copyright code that is a bit of a graduated warning scheme for pirates, domestic pirates, that went through but has now got bogged down because the rights holders and the ISPs are arguing about costs. And we've also just had the Trans-Pacific Partnership that goes through. The Trans-Pacific Partnership, to be honest, shouldn't change any of Australia's copyright laws per se. It cements in all of the bad stuff, so all the extension of term and all the bad TPM things, all of those horrible things that we already agreed to under the Australian-US Free Trade Agreement are now cemented into cement, which is not great. More importantly for Australia, the big problem with the TPP is that we have an ISDS provision, which is investor-state dispute settlement. That means that corporations will be able to sue Australia if they pass laws that impact on their investment if they're not in accordance with the IP chapter. So this makes things like flexible exceptions like fair use, or maybe some interesting things around geo-blocking, actually challengeable and suable, which is not an excellent place to be in. So that's what we got, which I was fairly unimpressed about, to be perfectly honest. What would we like to see in the short term? Now, I have to say, I actually think in the short term, we are beginning to look really good. There has been a lot of work, and some of your key groups, people like ALIA and the National Estate Libraries Australasia and the Australian Society of Archivists and all of the various library groups have been working actually incredibly hard to get some good copyright reforms through. And I think we're looking reasonably good on a couple of levels. We'd like to see a fix to preservation copying for a start, so that preservation copying actually copes with digital, so that we can do things like preserve websites. That's looking reasonably happy with any luck. Obviously, the big one is trying to stop copyright on unpublished works being perpetual. Again, with any luck, that will turn up in the foreseeable future. We're hoping that we can get an extension of safe harbours. So the safe harbours are basically a set of procedures that libraries can take that protects them from infringements that their users take. In the US, the safe harbour provisions cover Facebook and Twitter and libraries and schools. We don't have that extension to libraries and schools here. Hopefully we will get that. Longer term, we've got a Productivity Commission ongoing review into IP, and we're hoping that will give us some really good recommendations that we could leverage to perhaps get a good sensible approach to orphan works. So something like a limitation on liability when you use orphan works if you've done a diligent search, which just makes risk management a lot easier. We're hoping that we might get the big one of all of them, which is fair use. That gives us the flexibility to deal with basically changes in technology. When things change, instead of having to try and look for a new copyright exception, we can just have that central question is the use fair? So this is my current image of copyright in Australia, i.e. Tower of Babel, everyone's shouting over each other, nobody can agree on everything, we're all talking at cross purposes, and the whole thing is a bit chaotic. I am hoping by the time I get back from my Santiago jaunt, this is what it's going to look like. Orderly, calm, productive, peaceful public domain artwork. Okay, so that wraps it all up for that. We will now wander through to the rest of the questions. I've got one in my chat here. Let's have a look. What does it say? I have a question regarding government, the state holding copyright where there is no next of kin. The estate is described as bona vacanti and the state takes the assets. While the state has entitlement, there is a provision for the state to distribute the assets to anyone with a moral claim to the assets. This could include an informally adopted child or any other person who is dependent on the deceased at the time of death. But in the event no one is able to be found, does that mean copyright is held by the state? If the assets of an estate actually default to the state, so the state ends up picking up all the assets, yes, the copyright will end up being the state. Interestingly, if the state ends up owning the copyright, any copyright that the state owns becomes crown copyright, and crown copyright only lasts for 50 years, and it's treated differently in a whole series of subsections. So at that point, you would be looking at the crown copyright rules. Okay, what have we got here? yeah, I have to definitely agree with Vanessa. Don't, unless of course you dress up as a Disney character. Disney just pushes your risk profile way through the roof. If a distance student asks us to copy what they could copy under their exception, and I'm right that we still cannot copy more than 10% on their behalf. Okay, couple of things. One, remember, as libraries, you cannot copy for people under the research and study exception. So you can't just have a student who says to you, I could copy 10% of this under research and study. Can you copy it for me? Because you can't use their research and study because it's a personal research and study exception. What you can do is use section 49. So you are going to actually have to get them to go through the formalities of section 49, which basically requires them to swear on their grandmother's grave that they need this 10% for their own personal research and study and they won't use it for any other purpose, and then you send it to them. If the work is not available, reasonable time, ordinary commercial price, then you can copy more than 10%. But if it is available, then 10% is all you can copy, unless what they're after is an article in a periodical and they want more than one article and those articles relate to the same course of research and study. You can send them up to the entirety of the periodical if they relate to the same course of research and study. If we have audio books on CDs, but our new computer no longer have a disk drive, can we rip the audio tracks as MP3s? I would say yes, but you can't then treat them any other way from CDs. And that's a bit of a flippant answer. There's a couple of other things you're going to have to go and have a look at when deciding whether you can fit that under Section 200AB. But definitely for a number of cases that will be possible. If it's not possible to buy the CDs anymore, it will definitely be possible under Section 200AB. For anybody out there who hasn't already, if you go to the Australian Libraries Copyright Committee, so it's lib copyright, it's libcopy, I think, LIBCOPY, or it might be lib copyright. Anyway, .org.au, or just Google the Australian Libraries Copyright Committee. In the resources, there is a booklet called the Section 200AB booklet. Section 200AB booklet goes through all the legal mumbo jumbo for half of it, and then it has an entire half of a booklet that just runs through case examples, and there is one on format shifting for obsolete formats. Go and read that. It's got all the various little bits and pieces that you might need to consider that would shift the equation one way or another under a Section 200AB analysis. In relation to the question you just answered about 100% copy of an out-of-print item being made available online, would that be okay if only staff and students of the university could log in and access it? That would be a Section 200AB risk management analysis. I think I would once again recommend going and picking up that Section 200AB booklet and finding somebody else to talk through some of the ins and outs of that. Art galleries often say they hold copyright on a work in the gallery no matter how old. Is that correct? No, it is not. And that unpublished works thing, by the way, doesn't work for artistic works. So there's perpetual copyright on unpublished works, but not artistic works. They've always been excluded because of the way that you don't generally publish paintings or you don't publish sculptures. And that's the reason that unpublished photos that were taken pre-55 also don't count as unpublished works. So art galleries don't, but they may have, what they often do is try and put contractual restraints around use of stuff. How am I going for time? So who's going to kick me off in 2 minutes? I've got two more questions for you, two. I'll answer them really quickly. 10% in regards to compilations of songs. Does it apply to 10% of the whole book or 10% of the song? Is there a difference between a compilation of one artist and a compilation of various artists? The deal is that 10% rule doesn't actually apply to music in the same way. So music is a completely different thing. I can't answer it really quickly here, but music is different, and I'm pretty sure there's some resources on the ALCC webpage, and if there's not, there will be in the next 3 months that will actually run through those music copyright things in a lot more detail. University of Australia also is a good place to go for music copyright. And then if you work in an educational library, can you copy for the student under 5B rather than Section 49? And does that mean that you don't have to get them to fill in under a form? You can definitely do a whole lot of stuff under Part 5B. Once again, you've got limits on the amount, and that's the 10% limit again. But you can use that to say put all your readings up as coursework and all of the various things. The detailed stuff on Part 5B, which obviously I don't have time to do in the 20 seconds before Hugh kills me, is best talked about with Universities Australia. They've got the best resources for that. And to the person who missed the answer to the CD ripping question, I will say again, go to the Australian Libraries Copyright Committee webpage, go and find the Section 200AB handbook, and it has an excellent case study on format shifting that should be fairly directly applicable to you. And now I'll let you talk.
Thank you, Trish. You're an absolute professional there. Right on time. I'm really sad that we can't give you a virtual round of applause because you can't hear anybody. But I can tell from the questions that everyone really enjoyed that and got into it. And I like how you very politely avoided saying maybe to some of those questions by, being a bit of a lawyer. So that was good. Just before everybody runs away, because I'm less interesting than Trish, thank you so much for being on our webinar today. Our next VALA event is Lightning Talks at the Dock, at Library at the Dock. And there's my page. That's on Wednesday, the 25th of November. And details and registrations will be coming soon, so keep a lookout for the email, or if you're following us on Twitter, look there, or just check out the VALA website. And don't forget that registrations are open for the VALA 2016 conference, which will be in February. That's from February 9th to the 11th in Melbourne, as usual, at the MAC. So if you haven't got your tickets already, please register or talk to your boss about registering, or start writing your application about why they should pay to send you to Melbourne and go to the VALA conference. Thank you so much for being part of it, and we'll see you, some of you at least, at Lightning Talks to the Doc on the 25th of November. Thanks for being part of it.